Hello, everyone, and welcome to the Whistleblower Overview Virtual Learning Session, presented to us by the Office of Counsel to the Inspector General. To participate in the discussion today, or to ask questions, please use the area to the left of the presentation slides that is entitled Ask a Question. Below the Ask a Question banner, there's a section where you are able to submit your questions or comments. Below that Ask a Question area, you will see a section named Event Resources. In the Event Resources section, you will be able to download a copy of the slide deck that is being presented for you today. We have the pleasure of having the Acting Director of the Office of Head Start with us today to open up our call, Dr. Ann Linehan. Dr. Linehan, the floor is yours.
Well, thank you. I just got a doctorate for free. Thank you very much. I'd like to welcome the Head Start community again to the Whistleblower Overview Virtual Learning Session. And I have to tell you, there are over close to 550 people who felt this training was important to log on today. And I want to congratulate you. I think that we have been so inundated with so many things COVID-related that sometimes we tend to overlook the other parts of our managing as leaders, as you do, running organizations, other important aspects. And I think today is a topic that really is very beneficial for us all to be aware sort of what our roles and responsibilities are in this process. We are so happy to have joining us from the Office of Counsel to the Inspector General, Iana Esters. Iana is the HHS Whistleblower Protection Coordinator and the Deputy Branch Chief of the Operations Team within the HHS Office of Inspector General, Office of Counsel to the Inspector General, and Marissa Hill, an Associate Counsel on OCIG's Operations Team, which provides legal advice to the Office of Inspector General on law enforcement, fiscal and information law matters, including whistleblower reprisal matters. The Office of the Inspector General is responsible for investigating whistleblower reprisal claims related to all Head Start, all HHS grantees and sub-grantees, and this includes, of course, Head Start grantees and sub-grantees. Today's learning session will focus on the whistleblower protections grantees and sub-grantees employees have, the whistleblower reprisal investigation overall, and OIG's role in investigating whistleblower reprisal allegations, and the obligations you as grantees and sub-grantees have in an OIG whistleblower reprisal investigation. Once again, I would like to welcome Iana and Marissa, and I will turn it over to you. Thank you very much.
Thank you so much, Anne, for that wonderful and warm welcome. Good afternoon, everyone. My name is Iana Esters, and I am the HHS Whistleblower Program Coordinator, and I am joined here today by my colleague, Associate Counsel Marissa Hill. On behalf of the HHS Office of Inspector General, the Office of Counsel to the Inspector General, we thank you for taking the time to learn more about federal whistleblower laws and how they apply to HHS contractors and grantees. We would also like to thank our partners in the ACF Office of Head Start for hosting this webcast. Let's get started. So for today's agenda, I will first start talking about the role of the HHS Whistleblower Protection Coordinator and what we do in my office. We will then go into a discussion about whistleblowers in general, what is a whistleblower and what is not a whistleblower. And then Marissa will take over to discuss our whistleblower statutes for HHS contractors, grantees, subcontractors, and sub-grantees. We will end this presentation with a discussion of the OIG's role in whistleblower reprisal investigations. We will be taking questions, so if you have any questions during this presentation, please feel free to put them in the chat, and we will be sure to try to answer them at the end of the presentation. With that, let's start talking about the Whistleblower Protection Coordinator and what my role is for the department. If you've ever heard of the Whistleblower Ombudsman, it is essentially the same exact wording for the coordinator. We just received a legal change in a statute, and the name for the Whistleblower Ombudsman is now the Whistleblower Protection Coordinator. Our authority, it comes from the Inspector General Act, Section 3D, and I like to use the acronym EPIC to describe what we do as Whistleblower Protection Coordinators. The first, the E, is educate. I'm responsible for educating HHS employees on their whistleblower protections. And while in the statute it indicates HHS employees, we extend that educational portfolio to grantees, sub-grantees, contractors, and subcontractors as well. The P in EPIC stands for promote. We're responsible for promoting the timely and appropriate handling and consideration of protected disclosures and allegations of reprisal. What that means in plain English is that we are responsible for making sure that when a grantee employee files a complaint with us for whistleblower reprisal or reporting fraud, waste, and abuse, that it is handled in a timely and appropriate manner, and we work with our Office of Investigations to do that. The I in EPIC stands for inform. We provide information to whistleblowers on the timeliness of their retaliation or reprisal complaints, any alternative dispute resolution arenas that may be available for them, for instance, mediation, and other avenues of release that they may have in the event of retaliation. And then the C in EPIC stands for connect. We're responsible for coordinating with HHS, such as our partners here in the Office of Head Start at ACF, the Office of Special Counsel, the Councils for Inspectors General on Integrity and Efficiency, or CIGI, Congress, and others on any issues related to whistleblower reprisal complaint timeliness, the appropriate handling of any whistleblower disclosures or reports that we receive, and of course the implementation and administration of whistleblower protection laws, rules, and regulations. Now I'm going to talk about briefly what whistleblowers are. So who is a protected whistleblower? The OIG receives complaints literally every day, and in a large majority of those complaints, the complainants indicate that they are a whistleblower. But not every person who files a complaint with us is considered to be a protected whistleblower under federal law. There are really only 4 buckets of individuals who are considered to be protected whistleblowers. The first bucket are federal employees, both civilian employees and our military employees for HHS. That would be the U.S. Public Health Service Commission Corps officers. Applicants for federal employment are also protected whistleblowers. Federal contractors and subcontractor employees, including our personal services contractors at HHS, are considered to be protected whistleblowers, as are many of you who are on this call. Federal grantee and sub-grantee employees are considered to be protected whistleblowers. So who is not a protected whistleblower under the law? Medicare and Medicaid beneficiaries. So if someone were to lose their Medicare or Medicaid benefits because they filed a complaint with the Office of Inspector General, we would not be able to investigate any sort of retaliation complaints that they bring because Medicare and Medicaid beneficiaries are not protected whistleblowers. Nor are providers who deliver health care services under a Medicare or Medicaid provider agreement. Those healthcare professionals who work under provider agreements are not considered to be protected whistleblowers because a provider agreement is not a contract with the federal government. Employees of insurance or pharmaceutical companies are also not considered to be protected whistleblowers. And last but not least, concerned members of the public are not considered to be protected whistleblowers. So what's the difference between a whistleblower disclosure and a whistleblower reprisal complaint? So whistleblower disclosures essentially are complaints from anyone that falls into one of those 4 categories that we just discussed: a federal employee, applicant for federal employment, contractor, subcontractor, grantee, or sub-grantee, who alleges unlawful activity. That complaint of unlawful activity is considered to be what's called a whistleblower disclosure, or a protected disclosure is another word for it. A whistleblower disclosure is a complaint of fraud, waste, or abuse, including complaints of substantial and specific dangers to public health or safety, including safety of a minor, for instance, or unlawful activity that is filed by one of those protected whistleblowers. Whistleblower retaliation is a different complaint altogether. It is essentially when someone receives an adverse personnel action as a result of them reporting a whistleblower disclosure. So when an employer takes or fails to take an action against someone, or they threaten to take or fail to take an action against someone for making a report to the Office of Inspector General or to the Office of Head Start at ACF or any other sort of protected sources that we will discuss later, that is considered to be whistleblower retaliation. We also call it whistleblower reprisal. The two words mean the same exact thing. To make it plain, when we receive a protected disclosure or a whistleblower disclosure, the wrongdoing in a complaint there is the illegal activity that's being reported by the whistleblower. It's fraud, waste, or abuse. Whereas when we receive a retaliation complaint, the wrongdoing in that complaint is that adverse personnel action that was taken against that whistleblower because they made a protected disclosure. In those instances, we're looking at the retaliatory personnel action and not the fraud, waste, and abuse. The interesting thing about a whistleblower reprisal complaint is that every complaint that is a retaliation complaint actually creates two cases of investigation for the Office of Inspector General. For instance, the allegation of retaliation is one investigation in which the OIG will be looking at whether or not there was an adverse personnel action that occurred. The second complaint that we would also look at is the underlying fraud, waste, or abuse that the whistleblower reported. In OIG, the retaliation cases are always investigated by our special agents in the Special Investigations Branch of our Office of Investigations, or SIB. The fraud, waste, and abuse case that was reported by the whistleblower, what we call a disclosure case, can be worked by any special agent in any of our OIG regional or field offices, or SIB as appropriate. So I also wanted to spend some time also talking about the disclosure laws under the Inspector General Act. Section 7B of the Inspector General Act says that OIG shall not, after receipt of a complaint or information from an employee, disclose the identity of that employee without their consent, unless the Inspector General determines that such disclosure is unavoidable during the course of an investigation. Section 8M also prohibits us from disclosing the identity of any individual who files a complaint with the OIG hotline without their consent. So what that means is that when an employee complains to the OIG, we are prohibited from disclosing their name, their identity to anyone, even to another HHS agency. That also prohibits our release of any identifying information about that complainant employee, their address, their email, their phone number, their work unit, or other personal identifiers that they may have. We're prohibited from disclosing their names unless it's unavoidable during the course of an investigation. Now, when might it be unavoidable during the course of an investigation? Typically, that is when we have a retaliation case. Because if we were to go out to any grantee organization and request, for instance, the personnel records for that employee who complained of retaliation, we would need to be able to disclose their name to do it. As a result, for retaliation cases, we always ask the complainant for their consent before moving forward with investigating those cases. Grantees and contractors have mandatory reporting requirements to the OIG or to HHS in general. For our contractors under the FAR, the Federal Acquisition Regulations, contractors for HHS are required to disclose information sufficient for law enforcement to identify the nature and the extent of any violations and to identify individuals who may be responsible. Our special agents in the Office of Investigations are law enforcement officers. For grantees, the Code of Federal Regulations 45 has mandatory disclosure requirements for any grantee employees. That would be Office of Head Start grantee employees, for instance, to disclose in writing to HHS or any pass-through entity all violations of federal criminal law potentially affecting a grant. Additionally, the OIG has authority under 45 CFR to receive the right to records, documents, or papers, as well as the right to interview grantee personnel as a part of their investigations. And with that, I will turn it over to my colleague, Marissa Hill, to speak a little bit more about the whistleblower statute.
Thank you so much, Iana. We'll now turn to focusing on the NDAA, which is the Contractor and Grantee Anti-Retaliation Statute. So the NDAA, we get that acronym from the National Defense Authorization Act for fiscal year 2013. That's where this whistleblower protection first appeared. It's now codified at 41 U.S.C. 4712. The NDAA expanded whistleblower protections previously only allowed for federal employees to employees of all federal contractors, subcontractors, grantees, and sub-grantees. The NDAA provides that a protected individual may not be discharged, demoted, or otherwise discriminated against in reprisal for making a protected disclosure. The NDAA also requires that HHS or any federal agency ensure all of its contractors and grantees have informed in writing all employees of whistleblower protections, rights, and remedies. So to briefly go back over protected disclosures, as Iana did earlier, under the NDAA, information that is reasonably believed to evidence violation of law, rule, or regulation related to an HHS contractor grant, gross waste or mismanagement of HHS funds, abuse of authority related to an HHS contractor grant, or substantial and specific danger to public health or safety. It's important to note that the whistleblower's disclosure does not need to be an actual violation of law, just that the whistleblower reasonably believed it was evidence of such. Some things that are not a protected disclosure under the NDAA include violations of Title VII discrimination laws. This includes discrimination based on your race, gender identity, sexual orientation, and religion. Similarly, union grievances or labor law violations are not protected disclosures under the NDAA, nor are administrative grievances or workplace disputes. So protected disclosure is what the whistleblower is saying, but it also matters who you're saying it to. That's what we call the protected source. Disclosures by contractor or grantee or sub-grantee employees are protected only when made to a member of Congress, the OIG, the GAO, any HHS employee responsible for contractor grant oversight, including our friends over at OHS, DOJ, another law enforcement official, court or grand jury, and most significantly, a lot of you, management or employees of the contractor or grantee who is responsible for investigating, discovering, or addressing misconduct. That means you can receive protected disclosures from whistleblowers. There are a few other things that make the NDAA special. One of them is two different rights to sue. One is the right to sue the employer. The NDAA gives complainants the right to sue the grantee or sub-grantee once remedies are exhausted with the OIG. If the NDAA gives if the HHS secretary gives an unfavorable decision to the whistleblower, the NDAA gives the complainant the right to sue the secretary themselves. The NDAA also gives the secretary the ability to enforce any order to remediate retaliation against the contractor or grantee employee. We'll talk about that a little bit more later. Something else unique about the NDAA that we wanted to emphasize is that HHS must ensure all contractors, grantees, and subs have informed in writing all employees of whistleblower protections, rights, and remedies. And this notification requirement is codified at 41 U.S.C. 4712. So what does an OIG whistleblower reprisal investigation look like? We're just going to go through the basics of what makes an NDAA investigation unique and what might happen if a special agent came knocking at your door. So under the NDAA, 180 days is how long the statute gives for between the receipt of the complaint to when a report of findings must be submitted to the HHS secretary. However, these don't always happen within 180 days. Extensions can be granted, but they have to be mutually agreed upon by the complainant and OIG. OIG cannot unilaterally extend the time period in NDAA cases. In the report itself, the IG submits this report of findings of the investigation not only to the complainant, but also to the contractor or grantee involved, as well as the HHS secretary. The secretary himself then determines whether there is a sufficient basis to conclude that the contractor or grantee concerned engaged in retaliation, and they must do so within 30 days of receiving the IG's report. They then issue an order denying granting relief, and that relief can really range from something as small as a little bit of back pay to reinstatement or a promotion that was denied. You'll see what listed some of these here. Secretary can order a grantee to take any kind of affirmative action to abate the reprisal, anything to make the person whole again. The secretary can also order the grantee to pay the complainant an amount to equal all costs and expenses reasonably incurred by the complainant in bringing their complaint to the OIG. If a contractor or grantee does not follow the secretary's order in remediation, it can be enforced lawsuit in federal district court. So just to recap what we really hope you take away from NDAA, 4712D again requires that agencies ensure contractors, grantees, and subs inform their employees of their whistleblower protections. HHS-OIG has sole jurisdiction to investigate whistleblower retaliation complaints under the NDAA. They cannot be investigated by other HHS investigative entities. Similarly, HHS-OIG cannot, under the IG Act Section 7B, disclose the name of any whistleblower without their consent, unless it is unavoidable during the course of an investigation. And I'll turn it back over to Iana.
So this slide just provides our contact information if you have any additional questions that we're not able to answer here today. The first one is our OIG hotline, which is where your grantee employees can file any sort of complaints that they have, whether it's a retaliation complaint or a fraud, waste, and abuse disclosure complaint. That's through our report fraud website, or they can call 1-800-HHS-TIPS if they would like to file their complaints that way. We've also provided on this slide the email address for me, the whistleblower coordinator, which is whistleblower.coordinator@oig.hhs.gov, as well as a couple of helpful links on whistleblower protections that are on our website, including a notice to HHS contractors and grantees that provides that pretty much a synopsis of the information that we have provided with you today regarding what the protections are for grantee and contractor employees under the NDAA, the whistleblower laws. And with that, I think that we can open it up for any questions.
So there's a lot to unpack here. My head is spinning, and even as a federal employee, I have a lot of questions, but let's get to our audience's questions first. The first one is, are 1099 contractors protected?
So a 1099 contractor is simply an independent contractor. The statute does not make any sort of distinctions between the types of contractors that are protected under the law. It doesn't even have a definition of a contract. So essentially, if you have a contract subject to the federal acquisition regulations, even if it's a sole source contract with an HHS entity, then yes, the employees of that contractor are protected. As is, if it's a sole contractor and it's just an army of one, and you feel like you're retaliated against, you would be covered under that statute.
So let me give you a concrete, I think I understand you. Let me give you a concrete example. We have many, many Head Start programs that have arrangements, contracts, consultant agreements with, let's say, a mental health coordinator who might work, for the agency 20 hours a month or 30 hours a month. Would that person fall under the protected category?
If that person has, for instance, is considered to be a subcontractor, maybe with that entity, then yes, they could be protected.
So I think that's probably the part that is maybe if we need to tease out what is a subcontractor versus a consultant or someone that just has it feels different to us, a sub-grantee versus a contractor who may be employed, be paid 30 hours a week or something, or a month.
I mean, it's a very interesting question because the statute itself does not make sort of a distinction. A consultant, for instance, someone who doesn't really have any sort of a contractual agreement with the contractor or a grantee probably wouldn't be covered, but we would have to look back at case law to see if they have ever determined if a consultant is as a carve-out for the NDAA, for the grantee and contractor statute. So we can certainly provide that information to you all at a later time after we've done a little bit more research on the consultants.
Because I think it leads to the question where you talked about 41 USC about HHS must ensure all contractors, grantees, and subs have informed in writing all employees of whistleblower protections. So, that's not something the board has to approve because it's a federal requirement. So I'm wondering in what situations, for example, where there are clear contracts, then grantees are really responsible to have notified that contractor in writing of these protections. Is that accurate?
Yes, that is accurate, that they would have to notify those contractors in writing, that the grantee organizations would have to do that as well, that they would have to write both their sub-grantees, their subcontractors, any of their contractors, they would have to notify that population in writing of these protections. And one of the things that we've kind of tried to do to make it a little bit easier on grantees and contractors is one of the links in the slide deck on that last page is an NDAA notice to HHS contractors, and that's what OIG uses to notify its contractor population and grantee population. Any contractor or grantee could take that notice and provide it to their own folks and their own contractors and grantees, and that should satisfy that requirement.
Oh, that's great. Maybe we could kind of lift that out and make it easy for folks to see what it is. Let me ask you, so I'm not surprised this question came in. We think about employees and we think about contractors, but obviously Head Start parents play a big role. So someone asked, if a Head Start parent who is on Medicaid or Medicare makes a complaint, are they not protected under the Whistleblower Protection Act?
That's an excellent question, and the answer is that they are not protected. Medicare and Medicaid beneficiaries in general are not considered to be protected under the Whistleblower Protection Act or the NDAA or under any other sort of federal whistleblower law that we're talking about today. Now, there is an entirely other statute, a False Claims Act, that does have its own key TAM whistleblower retaliation provisions underneath that particular law when there's been a false claim against Medicare and Medicaid, and that is a completely different statute. But no, they are not protected under the Whistleblower Protection Act.
Okay. And again, these slides, we will post them on our website, but anyone that's watching this, I mean, anyone could download these and share them, correct? There's no prohibitions here?
That's correct.
Okay. Another question, does the FWA investigation also extend to any allegation that a Head Start regulation was not followed?
Yes, it would. That would be considered to be something that is an unlawful activity. The list as to what is considered to be a protected disclosure goes to many things, including those sorts of unlawful activities, gross mismanagement of funds, a substantial and specific danger to public health or safety. It covers a lot of things. And so, yes, that would definitely be something that would be covered.
And what about the situation, you said in some cases if the OIG decides that they have to disclose the person's name, that's sort of their authority to do so. But what about in the situation where you're giving someone a choice and they say, no, I don't want my name to be disclosed? What happens in those cases? Does it proceed? Does it weaken the case?
So that's a great question, too. It really depends on the type of complaint that they filed. If the whistleblower has filed a retaliation complaint and they indicate, I just don't feel comfortable giving consent for the disclosure of that complaint, unfortunately, our Office of Investigations is going to have to close that complaint because there's no way that they can investigate a personnel action without providing the grantee or the contractor with the name of the employee in order to get their personnel files and to investigate it properly. So if it was a retaliation complaint, failure to give consent leads to the closure of the complaint, and the complainant is made aware of that. If it is a disclosure complaint, where we're talking about fraud, waste, or abuse, or reporting of unlawful activity, there hasn't been any sort of retaliation. In those instances, it really depends on the type of evidence that we receive as to whether or not we close it. If we have enough evidence that the whistleblower is able to provide to where we could do a thorough investigation without having to disclose the name of the whistleblower, and then we may move forward with doing that investigation. But if we can't, then we would have to notify the complainant that we won't be able to move forward with the investigation.
Another interesting question came in because, in Head Start, we rely on parent volunteers. And sometimes when parents volunteer, depending on what they're volunteering, grantees can count that as part of their non-federal share. So it's like revenue to the program meeting your match. So the question came up, is volunteers, and I think in this case it would be specific, are people that are volunteering in the Head Start program, are they covered?
No, because volunteers are not considered to be employees of the organization.
Okay. Could you review for both grantees that are listening, and I am sure there's some federal staff on this that are listening, what our responsibilities are if I am a grantee and my employee comes to me and discloses something that falls under whistleblower, but they kind of don't know that the person making the complaint doesn't even know that they're sort of protected under the Whistleblower Act. Is the grantee responsible to inform them of that, or is the grantee have any responsibility because they know it? Does someone have to say, I'm a whistleblower for something, for them to be protected?
That is a great question as well. And the answer to the question of whether or not the person has to say, I'm a whistleblower in order to assert that right, they do not have to use those magic words. The rights go along with the position. So if the employee is an employee of a grantee or contractor or federal employee, they automatically have whistleblower protections, regardless of whether or not they, assert that they are, saying I'm a whistleblower and I'm making a complaint. The responsibility for a manager who receives one of those sorts of those complaints is to, if it's a complaint, for instance, of a fraud, waste, and abuse, they can be, and it's something that, for instance, it's criminal. They can persuade the employee to go ahead and report that criminal action to the Office of Inspector General through our hotline. If it's, if they feel like they were retaliated against within the organization because of a prior disclosure, they will have they also have that right and can be told that they can report it. Or, the organization can try to remediate any sort of retaliation that they believe has occurred and do their own investigation as well. However, that does not alleviate the employee's right to be able to file a complaint with us on either end. I should also mention for federal employees who are on here, HHS employees who are listening in, that your role is twofold. If you're in a grant management or grant oversight position, you could receive whistleblower disclosures from the grantee's employees, but you also have your own rights as well. And for HHS employees, you'd have the opportunity to not only just report to the Office of Inspector General, but the Office of Special Counsel also receives whistleblower retaliation complaints, but only from federal employees. So that option is not available for the grantees and the contractors.
So there is the potential that an employee or a contractor could have a legitimate complaint, makes that complaint to the grantee. The grantee never really provides the whistleblower protections and just, I guess what I'm getting at, is there a lot of this that can go undetected because people are really not aware of their rights?
And that is why the statute requires that grantees are responsible for notifying their employees of these rights. And the way that they could do that, in written form is by use of, an NDAA notice like the one that we have on our website, or in some other fashion, or by, allowing employees, for instance, to tune into a webcast. But they are responsible for making those notifications.
Okay. Tanisha, did you have a question?
I was just clarifying or just making certain that the onus would be then on the onus is not necessarily on the person or the employee making the whistleblower complaint to say I'm a whistleblower. The onus to know that and to understand what goes along with what's being reported to them falls on management, on the grantee, and for us as federal staff as well when we're receiving that information. So I'm glad that we have the option to upload the templates. I know we received some questions about, well, how does this notice look like? What would it entail to put people on notice about their rights and what's offered under this act? So we can upload. You said that there's a link to that, Ayana, on your website to the NDAA notice?
Yes. If you look at this last slide that is up now, the second bullet from the bottom, NDAA notice HHS contractors, that is our notice to all HHS contractors and grantees about what their rights are, and it summarizes on a one-page sort of document, what those rights are. You can simply, peel that off and send it on out to your grantee employees and your contractor employees, and you'll be in compliance.
Perfect. Thank you.
don't know that we have any other, there's a lot of information here to absorb, but I think that you've broken it down for us, that we kind of are walking away knowing what it's all important, but sort of what we really need to know, both as grantee leadership, federal staff, and our obligations to really make this known to the people that we employ. It's really important.
Thank you. And anything that we can do, even as a follow-up after this call, that would be helpful for, the Office of Head Start or any of the grantees or contractors to get more of the word out on whistleblower protections. We are all ears, and of course answering any additional questions that anyone may have. Please feel free to contact us. For the grantee population out there, you can always feel free to email us at whistleblower.coordinator@oig.hhs.gov. I will put this plug out there that the grantee whistleblower statute is not that old. It's only been around since 2013. And so, case law in this area is constantly evolving, and new categories of individuals being covered by the federal whistleblower laws change all of the time. With new Congresses, different things change. And so, we will always update our website and update and provide the most pertinent information about this. But please feel free at any time to give us a call if you have any questions, or contact us by email, I should say, if you have any questions.
Well, we have one last question, which I think, and I hope I wasn't, I hope I was paying attention. You haven't answered it, but we talked about the template that could be easy to lift out, and that something that you could disseminate to staff. What if I said, you know what, I'm just going to put it in our personnel policies, and we're covered? Is that to me feels a little bit different than ensuring that your staff are knowledgeable about this? What is your sense of that?
Putting it in a personnel policy or in a personnel handbook is okay, so long as you end up disseminating it to staff and letting them know that it's been updated to include those whistleblower statutes, so that or whistleblower laws, so that there is direct notification of those laws. Okay.
Well, Iana and Marissa, we can't thank you enough, and there are over 700 folks that have been listening in. So I think you hit a chord even in this, this incredible time for us when we're so worried about the health and safety of our children and families and staff. It just goes to show you that people really do care about the other parts of business that continue despite the pandemic. So we really want to thank you. We're so happy that you reached out. I think this is kind of the first time that we worked in a joint training, so we really appreciate it immensely.
Thank you for having us. We really appreciate the partnership that OHS has given to us, and the opportunity to reach out to all of your constituents. So thank you so much.
Okay, thank you. And I guess we can bring it to a close, folks. Thank you very much. And keep safe. Keep safe and make good decisions based on local data.